Swayam Prabha. Digital India. Educated India.
Hello everyone, I am Dr. Kavita Solanki, Professor of Law at University School of Law and Legal Studies, Guru Govind Singh Indraprastha University, Delhi, Dwarka. Today we are going to talk about Labour and Industrial Law 1, into which we will talk about lecture number 5. It deals with Industrial Employment Standing Orders Act 1946. We would be talking about into this act, reason for having this act. What was the reason? Because before passing of this act, it had been realized that the condition of service of the industrial employee, they were not well, and they had been very ill defined, and they were hardly known to the employees. So it created a great confusion amongst them. The most of the industrial employment, the condition of service of the employees, they were not uniformed, and they were not even reduced into the writing. In order to overcome this difficulty and achieving harmony and peace into the industry, the Industrial Employment Standing Order had been passed. It was enacted to, basically to define the clarification and the precise condition of their service employment. The preamble makes it expedient to define the condition of the employment under them and to make the said condition known to the workmen employed by the employer. When we talk about the feature of this act is, number 1 is to have the uniform standing orders providing for the matters enumerated into the schedule of this act. That was not intended that there should be the different condition of service for those who are employed before and passing of this Standing Order Act, which came into the operation. Finally, once the standing order came into the force, they bind by those conditions, those who had been employed before passing of this act and those who had been employed passing of this act, uniformly the standing order would be applicable upon everyone. To provide the provisions for the standing orders, setting out the rules and regulations of the working conditions in factories, industries covered into this act. The act also aims for promoting peace and harmony in an industry, because to have this act, it would be finishing the conflicts between the employer and the employee. The liberty of the employer in prescribing the condition of the service was only limited to the extent that the standing order had to be into the conformity with the provisions which has been given into the Standing Order Act 1946. The Parliament in 1956, this act was passed in 1946, but the Parliament has widened the scope of the industrial employment in 1956. It now casts a duty upon the certifying officer to educate upon the fairness and reasonableness of the draft standing orders, and to make it compulsory for the employers to abide by the terms and the conditions, to provide better working conditions for the employees and their welfare, to promote the harmonious relationship between the employer and the employee. So this act has been passed with this intention. If we talk about this act consisting of 15 sections and 1 schedule. When we talk about the applicability of this act is, section 1 talks about the title, extent and the applicability. This act name is the Industrial Employment Standing Order Act 1946. It is applicable all over India. It applies to every industrial establishment wherein 100 or more workmen are employed or were employed on any day of the preceding 12 months. Provided that the appropriate government may, after giving not less than 2 months notice of its intention to do so, by notification into the official gazette, apply the provision of this act to any industrial establishment employing such a number of the persons less than the 100 as may be prescribed into the notification. It means this act would be applicable upon where the threshold of the employee is 100. Or if the government feels so to give the more protection to the employees. Now they would be notifying into the official gazette, and 2 months before they would be notifying into the official gazette of their intention for the protection of the employees, those who are doing into the industrial establishments. If we are talking about, because this thing has been changed now, but if we are talking about the service conditions, and we are having that is a code on industrial relations where this threshold has been increased. Instead of having the 100 employees, now that is the 300 has been done now. Nothing in this act shall apply to any industry to which provision of chapter 7 of the Bombay Industrial Relations Act 1946 is applicable, and the industrial establishment where the provision of the Madhya Pradesh Industrial Employment Standing Order is applicable. Reason is because they are governed by the central government. We are having here, we would be talking about the important definitions. So, first definition is I am taking, that is the appellate authority. It means it has been defined in section 2A, means any authority appointed by the appropriate government by notification into the official gazette to exercise in such area as may be specified into the notification and the function of the appellate authority under this act, provided that in relation to an appeal pending before the industrial court or any other authority immediately before the passing of the Industrial Employment Standing Order Act, the court of authority shall deem to be the appellate authority. Because the appellate authority would be, who would be the appellate authority that would be notified into the official gazette, and who would be taking the appeal if any of the parties moving to the appellate authority, say for example employee, employer or any trade union, they would be taking up all these matters. So, if they are not okay with the decision of the certifying officer, then the matter can be taken by the appellate authority. So, in section 2B it talks about appropriate government, section 2C it talks about certifying officer, because the role of the certifying officer is very, very important. In fact, we have discussed just now, that is because this had been realized, because act was passed in 1946, but again it had been realized in 1956. This the job of the certifying officer is to see the fairness and the reasonability of the standing order. Here when we talk about certifying officer, means labor commissioner or a regional labor commissioner, and includes any other officer appointed by the appropriate government by notification into the official gazette to perform all or any of the functions of the certifying officer under this act. Now, the question comes for the employer, because this is the job of the employer and it casts the utmost responsibility of the employer to have the good relation into the industry, have the amicable environment into the industry. So, employer here under this act is the owner of the industrial establishment to which this act for the time being applies, and it includes, if it is a case of the factory, in factory any person named under the clause F of subsection 1 of the section 7 of the Factories Act 1948, manager of the factory, because manager would be treated to be the employer in case of the factory, and in any industrial establishment under the control of any department of any government of India, the authority which has been appointed by the government or on their behalf. By chance, if no authority has been appointed, then the head of the department would be considered to be the employer. And in case of any industrial establishment, any person responsible to the owner for the supervision and the control of the industrial establishment. Now, the question comes, next definition is industrial establishment, industry whom we would be saying industrial establishment, where the standing order can be applied. Industrial establishment means an industrial establishment as has been defined in clause 2 of the Payment of the Wages Act 1936. It means those industrial establishment which are governed under which are included under the Payment of Wages Act 1936, they are considered here under this act. A factory, already I have said, that is factory in clause M of section 2 of the Factory Act is considered to be the industrial establishment. A railway as defined in clause 4 of section 2 of the Indian Railway Act 1890, the establishment of a person who for the purpose of fulfilling the contract with the owner of the industrial establishment employs workmen. Now, the most important definition of this act is, that is standing order. It has been defined in section 2G of this act. It means rules relating to the matter set out into the schedule. What kind of the terms and the condition has been laid down under this act is, what kind of the rules has been discussed laid down under this act is, we would be saying it is a standing order, but we would be reading it with section 3 clause 2. It means submission of draft standing order. Provision shall be made in such draft for every matter set out into the schedule, which may be applicable to the industrial establishment, and whether model standing orders has been prescribed shall be so far as in conformity with such model. It means standing order includes, that is draft standing order as well as the model standing orders. Now, what kind of the matters to be provided into the standing order under this act? This is very important, because here we would be talking of the matters, because if we are talking about the terms and the conditions, already if we are mentioning into this act is, so we can avoid the adjudication, we can avoid the conflicts. So, what kind of the matters can be provided into the standing order is, number 1, classification of workmen, like whether the employer is, whether this workman is permanent, whether the status of this workman, whether the person is on a permanent basis or on a temporary basis, or whether the person is doing any kind of the apprenticeships, or whether the person is a probationers, or whether the person is a badli or fixed term employment workman, especially into the apparel manufacturing sector. So, we would be talking about the classification of the workmen. Second is manner of intimating to workmen periods and the hours of work, holidays, pay days and the wage rates. It means we are talking about how that is number of hours, that is, because into so many industries we are having, that is 8 hours. Normally establishment, they start their work at, they open at 10 to 5, some establishments they start the work, they open at 9 to 5, so 8 hours normally, but because into which we will talk about the periods and the hours of work. Holidays, I mean how many holidays any of the workmen would be having, gusted holidays, or when we are talking about the restricted holidays. So, we would be talking about into the standing order. And pay days, I mean whether they would be getting the pays on the end of the month or into the next week of the next month. So, accordingly the time period. And the wage rates, because when we talk about the wage rates, the thing has to be very clear, like how much wages the person is getting, whether they are getting the 10,000 rupees, 15,000 rupees, everything we must have to mention it, and the time for giving the wages to the workers has to be stipulated, everything. After that, we would be talking about into this act is shift working, because into so many establishments we are having morning shift, we are having the evening shift. So, we must have to mention it very clearly. This workman would be doing for the morning shift or for the evening shift. Attendance and late coming, what is the time for reporting to any of the establishments? If someone is coming late, then in that case whether the absent would be marked. If the person is coming for 1 hour late, half an hour, 2 hours, so what is the criteria? Everything has to be mentioned. Condition of procedure in applying for or the authority which may grant leave and the holidays. If someone wants to avail the leave, what is the procedure? If someone wants to say, for example, because into the establishment we are having so many daily wage, we are having the migrant workers. So, if they are planning to visit to their respective villages, when they would be applying the leave, whom they would be giving the leave, if they want to take the holidays, so what is the procedure, whom to report, everything has to be mentioned. Requirement to enter premises by certain gates and liability to such, because if you are having the big industry, it is not necessary you would be entering into the into that industry from any of the gate, because the particular gate has been dedicated for the entry and the exit purpose, because they cannot use all the gates. So, which gate they can use it, and if someone is making the making the search without taking the permission, what is the liability in that case? closing and the reporting of the sections of the industrial establishment, temporary stoppage of the condition, closing and reporting of the sections of the industrial establishment. If the industry is opening at 7:30, that doesn't mean all the sections which are into the industrial establishment, they are doing the work, because they can have the different timings, reporting timing for the different sections. So, either someone is, for example, if we take the example of any of the business where they are doing the packing system is there, or otherwise they are doing kind of the cutting, packing or trading, we are having the different branches. So, if we are talking of this section means they can have the different timings for this, and if into that industry there is a temporary stoppage of the work and the rights and the liabilities of the employer and the workmen arising therefrom. Say for example, temporary stoppage of the work, it can be because of any other reason. There is a shortage of the raw material, because they are not having the raw material at that time, so they couldn't complete the work. If there is any kind of damage has been caused to the to any of the machine, they had to wait when they would be commencing the work again. Then in that case, what would be the liability in that case of the employer, whether they would be entitled for that wage or not. The thing has to be very clearly laid down into this thing. And termination of employment and the notice thereof to be given by the employer and the workman. If it is a case of the termination of the employment, they must have to mention the grounds for it, and because if they are going for the termination, they cannot do it with the immediate effect. They must have to give the notice in advance to the employee. So, principle of natural justice has to be taken care of. And after that, point 9 is, it talks about suspension or dismissal of the misconduct and act of the omission which constitute misconduct, because into this act we must have to be very clearly, we must have to mention it, what kind of the act or the omission or the errors would be amounting to be the case of the misconduct. We must have to lay down, because sometimes a person is not having the intention to do something bad, but the act amounts to the omission, so we must have to lay down. And if the person is on that basis, if they are making the dismissal because of this conduct, so they must mention the grounds for the omissions and the grounds for the misconduct under this act. Means of redress of the workman against the unfair treatment or wrongful exactions by the employer or his agent or the servants. If the person is, someone is misbehaving or doing the unfair treatment towards a particular employee, how these kind of the problems can be redressed, what is the procedure, whom they would be reporting, what is the mechanism to resolve this kind of this thing, and any other matter which may be prescribed, because sometimes it is not necessary all the matter has been given into this, because with the passage of the time, sometimes the things had not been mentioned there. But if the government feels so, okay, yes, this kind of the matter has to be mentioned into the standing order, then they can mention it after giving the notice in advance through their official gazette. Because when we talk about the other act, say for example, when we talk about into your minimum wages, into which, because the protection has been given it to whom? To the certain class of the employees, those who have been, that has been given under the scheduled employments. By chance that act is not, that employment has not been covered, then they can, this is the duty of the government, is they can notify and they can add that employment into the category of the scheduled employments. So, that is why under that particular act, under section 27, what they do basically, the appropriate government, they give the official gazette, and accordingly they can add that particular employment into the minimum wages. So, like we can avoid we can give the more protection. That is why the domestic worker, when we talk about, they were not covered anywhere, but because of this section 27 of the minimum wages, so many state governments, they have given the protection to the domestic workers under this category. The same likewise the case is here, the government, they can add it through their any other matter which has not been given here into this standing order. Now, if we are talking about the procedure of the standing order is, it is clearly mentioned in section 3. This is a duty of whom? Duty of the employer for the submission of the draft standing order, because within a 6 months from the date on which this act becomes applicable to any industrial establishment, the employer shall submit to the certifying officer 5 copies of the draft standing orders proposed by him for adoption into the industrial establishment. If the someone has started the industry, this is a duty of the employer is they must have to adopt the standing order within a 6 months. That standing order would be applicable upon that industry, and provision shall be made in such draft for every matter which we have discussed right now, that is such draft for every matter set out into the schedule which may be applicable to the industrial establishment, and where model standing orders have been prescribed shall be so far as is practicable. It has to be in conformity with the model, because if they want to have this standing order, they must have to apply. If they want to draft their own standing order, they must have to make the standing order with conformity with this model, this standing order model. The draft standing order submitted under this section shall be accompanied by a statement giving prescribed particulars of the workmen employed into the industrial establishment, including the name of the trade union, if any, to which they belong. Because into this standing order, draft standing order, what they would be doing, they would be taking the statement. This kind of the statement has to be given to the certifying officer. Say if into any of the industry we are having the number of the workmen, they are associated with the trade unions. If someone is associated with a trade union, they must have to give the name of the trade union. So and so is attached with this trade union, and they must have to give it. And subject to such conditions as may be prescribed, a group of the employees in a similar establishment may submit a joint draft of the standing order under this act. If we are having the two establishment having the similar kind of the work, they are having this kind of thing, so jointly standing order can be submitted. It is not necessary individually they would be submitting their own standing order, jointly it can be submitted. Now section 4, it talks about conditions for certification of this standing order. As we discussed, who would be making this is the duty of the employer is to make the condition, to have the condition that is in conformity with the model. But now talking about the condition for certifying the standing order. Standing order shall be certified under this act if provision is made therein for every matter set out into the schedule which is applicable to the industrial establishment. They must have to set out every kind of the matter which has been mentioned into this model, and the standing order are otherwise in conformity with the provision of this act, and it shall be the function of the certifying officer or the appellate authority to adjudicate upon the fairness or the reasonableness of the provision of the standing order. This is their duty. They would be confirm like every kind of the matter has to be included after making the confirmation with the model standing order. After that they would be looking into the whether this standing order is fair or reasonable enough. This is so, and section 5 is talking about on receipt of the draft under section 3 which we have discussed, the certifying officer shall forward a copy thereof to the trade union now, if any, of the workmen, or where there is no such trade union, if any, of the workmen, or where there is no trade union, to the workmen in such a manner as may be prescribed, together with a notice in a prescribed form requiring the objections, if any, which the workman may desire to make the draft standing order to be submitted to him within a 15 days from the receipt of the notice. Now, what they would be doing here, the certifying officer, because once the certifying officer would be receiving this standing order, they would be, before they certifying it, they would be sending a copy of this standing order to the trade union, because if any of the workmen is attached with a trade union, they would be send the one copy to them, and after giving the employer any trade union or other representative of the workmen as may be prescribed an opportunity of being heard, the certifying officer shall decide whether or not any modification or the addition to the draft submitted by the employer is necessary to render the draft standing order certifiable under this act, and shall make an order in writing accordingly. Because the employer is giving the opportunity, that's why they are sending the certifying of order, the copy of the one draft standing order to the trade union. If they are raising any kind of the objections, they have to take it and they must have to decide it whether this kind of the modification or whether this kind of the addition is required or not. If that is a reasonable or has to be added, they can add it. The certifying officer shall thereupon certifying draft standing orders after making such any modification. If they want to make the modification, they can go for this, and after that therein which his order under subsection 2 may require, and shall within a 7 days thereafter send copies of the certifying officers authenticated in a prescribed manner and of his order under subsection 2 to the employer and to the trade union and to the prescribed representative of the workmen. So now after making the modification, what this certifying officer would be doing, they would be certifying this copy, because they would be giving the authenticated copy, they would be giving the authenticated copy of this draft standing order to whom? To the trade union or to the representatives of the workmen. So that has to be given to them, because it would be considered to be the authentic. Now if question is of appeal, under section 6 appeal comes if any employer, workmen, trade union or any other prescribed representatives of the workmen aggrieved by the order of the certifying officer under subsection 2 of section 5 may within a 30 days from the date on which the copies are sent under subsection clause 3 of this act appeal to the appellate authority. It means if someone is not okay with the decision of the certifying officer, what they would be doing, either it is a case of the employer or it is a case of the workmen or trade union or any other representative of the workmen, within after receiving the copy, they can go for the appeal within a 30 days and appeal to the appellate authority, and the appellate authority whose decision shall be final and shall be ordered in writing confirm this standing order either in the from certified by the certifying officer or after making the amendment of this standing order by making such modification thereof or addition thereto as things necessary render the standing order certifiable, because that is they can go for the appeal, and this is the appellate authority has to take a call. If they feel so okay, there is a need for modification, there is a need for alteration, they would be deciding it, and accordingly they would be deciding this thing. The appellate authority shall within a 7 days of its order under subsection 1 send copies thereof to the certifying officer. If nothing has been changed, then in that case they would, because after the appeal within a 7 days the certifying officer, what they would be doing, appellate authority, they would be sending the copies and thereof to the certifying officer, to the employer and to the trade union or other prescribed representative of the workmen accompanied, unless it has been confirmed without amendment. The standing orders has to be certified by the standing order by copies of the standing order as certified by it and authenticated in a prescribed manner. Date of operation of the standing order, this is very important, because the things are ready when they would be implemented, when it will come into the operation of the standing order. Standing orders shall, unless an appeal is preferred, because if at the time for the appeal already we have done in section 6, come into the operation on the expiry of the 30 days from the date on which the authenticated copy they are sent, or wherein appeal as aforesaid is preferred on the expiry of the 7 days from the date. It means what we are talking about. Normally we are saying if it is a case of the appeal within a 30 days the thing would be decided without the modification. If no changes has been made, it would be automatically standing order will be coming into the operation after the expiry of the 30 days. If any slight modification has been done, then 30 plus 7, so 37 days after the expiry of the 37 days, it would be come into the application. Section 8 is talking about register of the standing order, because the registration is very important, and so for this a copy of all standing orders as finally certified under this act shall be filed by the certifying officer in a register, because this kind of the register they are in a prescribed format and in a prescribed form maintained for this purpose only, and the certifying officer shall furnish a copy thereof to any person applying there on the payment of the prescribed fee. they would be maintaining the record, that's why they would be making the entry into this register. If the someone wants to see what has been mentioned into the standing order, what are the terms and the condition. So, after giving the fee which has been fixed here, they can take a copy of it. Now, section 9 is posting of standing orders, because the posting of standing order is again a very important thing, because the text of the standing order as finally certified under this act shall be prominently posted by the employer in English and in the language understood by the majority of the workmen on a special board to be maintained for the purpose at or near the entrance through which the majority of the workmen enter the industrial establishment and in all the departments thereof where the workmen are employed. It is a very simple, but this is very important. They are saying as far as the posting of the standing order is concerned, where the employer would be making the posting of the standing order, they must have to place it into such a place where the majority of the workmen they can read, because they enter into any of the industrial establishment, when they enter into the premises, they will come to know these are the terms and the conditions. And as far as the language is concerned, English, they can use into the English, and the most important, they must have to use a language with the majority of the workmen they can understand. So, for example, into any of the industry where the majority of the workmen they understand Malayalam or they understand Punjabi, along with the English they must have to draft this standing order into that particular languages, Malayalam as well as in Punjabi, because otherwise they will not understand the language, and that is standing order has been drafted for the protection of the workmen, so they can understand what are the terms and the condition has been mentioned, and it has to be pasted on such a place, near the entrance through which majority of the workmen they can enter into the industrial establishment, or they can place it into their departments where these workmen they are doing the work, and into some of the establishment the special boards has been created to paste the standing order. Section 10 is talking about duration and modification of standing order. Standing orders finally certified under this act shall not, except on agreement between the employer and the workmen or a trade union or other representative body of the workmen, be liable to modification until the expiry of the 6 months from the date on which the standing orders are last modified thereon came into the operation. So, what is the time period for the standing order? Say for example, today we have prepared the standing order, and in next month if someone wants to modify the standing order, can they do so? No, not at all, because the standing orders finally certified under this act shall not, except an agreement between the parties. If the employer and the workmen or trade union or other representative they are okay with this, then they can go for the modification, but with the condition until the expiry of the 6 months. So, before the expiry of the 6 months nothing can be changed, they have to wait for after the expiry of the 6 months. And subject to the provision of subsection 1, an employer or a workman or a trade union or the other representative body of the workmen may apply to the certifying officer to have the standing order modified. So, they would be requesting it to the certifying officer to make the changes, and such application shall be accompanied by the 5 copies of the modifications proposed to be made, and where such modifications are proposed to be made by an agreement between the employer and the workman and a trade union and the other representative body of the workmen, a certified copy of the agreement shall be filed along with the application. Here what they would be doing after the expiry of the 6 months, they would be taking already the certifying standing order along with the proposed standing order, because that is ready with the modification. So, they would be taking it and they would be request to them for make the changes. So, they would be given the 5 copies of the modification which they are proposing it to the authority, and the foregoing provisions of this act shall apply in respect of the application under subsection 2, and they apply to the certification of the first standing orders. So, after that, now section 10A, it talks about payment of subsistence allowances. again a very important, because if the someone has been any of the worker has been, any of the, we would be saying workman has been suspended. So we are talking about, because we don't know for how long this suspension is going to be. So now, but this person is having the family and the responsibility, he has to take care of their bare subsistence level at least. So for this section has been drafted. Here, where any workman is suspended by the employer pending investigation or inquiry into the complaints or the charges of misconduct against him, the employer shall pay to such workman subsistence allowances, because this workman has been suspended by the employer and the investigation and the inquiry is pending and the charges are there. The person has done the misconduct. So this is the job of the employer, is they would be making the giving the subsistence allowances. So how much the allowances can be given is at the rate of the 50% of the wages, which the workman was entitled to immediate preceding the date of such suspension and for the first 90 days of the suspension. So how much the allowances can be, given? The allowances would be 50%. So for example, if the someone was getting 10,000 per month, the allowances would be 5,000 would be given to this workman, and for how long? That is for the first 90 days. It means for the first 3 months this allowance can be given it to the workmen during their suspension, and at the rate of the 75% of such a wages for the remaining period of the suspension, if the delay in the completion of the disciplinary proceedings against such workmen is not directly attributable to the conduct of such a workman. If the matter could not be resolved within this stipulated time after the expiry of the 90 days, 3 months has been over now. So how they would be managing other things? Now that is this subsistence allowance would be, that would be instead of the 50, now that would be the 75%. It means if someone was getting 10,000, now the 7,500 to be given to that person unless until the matter has been decided. If any dispute arises regarding, now the question is regarding this dispute is relating to the subsistence allowance, then if any dispute arises regarding the subsistence allowances payable to the workman under subclause 1, the workman or the employer concerned may refer the dispute to the labor court, because labor court under the Industrial Dispute Act, that is the power has been given to the labor court into one of the schedule. They would be taking up the labor court is the authority who would be deciding the matter, constituted under the Industrial Dispute 1947, within the local limits of whose jurisdiction the industrial establishment wherein such workman is employed or is situate, and the labor court to which the dispute is so referred shall, after giving the parties an opportunity of being heard, decide the dispute, and such decision shall be final and binding on the parties. It means if they are having any dispute regarding this subsistence allowance, number 1, the labor court is the authority who would be deciding the matter. And say for example, if the matter has been referred to the labor court, because it is not necessary if the person is, if that industrial establishment comes under the purview of the regional labor court, the matter would be taken, but sometimes the matter can be referred, then in that case the matter can be deciding by the, and the decision of the labor court would be final and it would be binding on the parties. Notwithstanding anything contained in the foregoing provision of this act, with the provisions relating to the payment of the subsistence allowances under any other law for the time being in force in any state are more than the beneficial than the provisions of this section. The provision of such other law will be applicable to the payment of the subsistence allowance in that state. This is very interesting. So if into one of these state, because we are talking about the standing order and we are talking about the subsistence allowances, if we feel so the other state is giving the more allowances, then they can take up the matter before the tribunal and they can go for the higher subsistence allowances. There is no problem. And after that, in section 11, certifying officers and the appellate authority to have the power of the civil court. Yes, before starting it, I have to tell you one more thing, that is because we are talking about, already we are ready with the labor codes, but when we talk about into the industrial relation code, now the role of the labor court is over now, because we are not having, we are with the limited authority, and the labor court, we won't be getting the labor court again into the industrial relations. So, section 11 is talking about certifying officers and the appellate authority to have the power of the civil court, because having the power of the civil court, the power of the civil court has been given it to whom? To the number one is to the certifying officer and to the appellate authority. So, every certifying officer and the appellate authority shall have all the powers of a civil court for the purpose of receiving the evidences, administrating the oaths, enforcing the attendance of the witnesses, and compelling the discovery and production of the documents, and shall deem to be the civil court within the meaning of section 345 and 346 of the Code of Criminal Procedure. If there is any clerical or arithmetical mistakes in any order passed by the certifying officer or appellate authority, or errors arising therein from any accidental slips or omission may at any time be corrected by that officer or the authority or the successor in office of such officer or as a authority as the case may be. Say sometime what happened, if we find any kind of the clerical or any arithmetical, there is a problem into the calculations, for example. So, this kind of the things can be rectified, they can make the corrections. Now, section 12 is talking about oral evidence in contradiction of the standing order not admissible, and no oral evidence having the effect of adding to or otherwise varying or contradicting standing orders finally certified under this act. So, like that will not be admitted into the court. Section 12A, it talks about temporary application of model standing order. Notwithstanding anything contained in section 12A, for the period commencing on the date on which this act becomes applicable to any industrial establishment and ending with the date on which the standing orders are finally certified under this act, come into the operation under this section 7 into that establishment, the prescribed model standing order shall deem to be adopted into that establishment, and the provision here, that is in section 9 subsection 2 of section 13 and section 13A, shall apply to such model standing order as they apply into the to this standing order so certified. So, a temporary application of the model standing order can be made, and nothing contained in subsection 1 shall apply to any industrial establishment with respect of which appropriate government is the government of the state of Gujarat and the government of the Maharashtra. Section 12A, where there are the two categories, because this is when we talk about the labor law, it has been given into the constitution, that is it is into the concurrent list. So, who is the appropriate government, and the appropriate government is competent enough to frame the standing order for their particular area or for those particular establishments. So, but where there are more than two categories of the workmen, one in respect of the daily rated workmen and other in respect of the monthly rated workmen. If there are certified standing order in respect of the daily rated workmen only, the prescribed model standing order should be deemed to have been adopted for those who are employed on a monthly basis until such categories have their own certified standing order. Because when we talk about the standing order, already we have discussed, standing order means the rules and the regulations which has been mentioned under this act, but that is because sometimes they are applicable, they are into the model standing order, sometimes they have not been adopted. So, model standing order is equivalent to the standing order unless until that particular industry they are not ready with their own certified standing orders. Now, the question comes for the penalties and the procedures. It has been given in section 13. It talks about an employer who fails to submit the draft standing order, because that is a mandate as required by section 3, or who modifies, either the person is not submitting, fails to submit, or who modifies his standing orders otherwise than in accordance with section 10 shall be because they are not making the modification which has been prescribed. He shall be punishable with a fine which may extend to 5,000 rupees, and in case of continuing offence with a further fine which may extend to 200 rupees for every day after the first during which the offence continues. So, first time the person can be held liable with the fine 5,000 rupees. If the person is again employer is doing with a continuously offence, then 200 rupees can be charged for every day. And an employer who does any act in contradiction of the standing order. The first case was where the person was not, he has not submitted, or otherwise the person would be liable. But here we are talking about section 13 clause 2 is employer who does any act in contradiction of the standing order, finally certified under this act for any of the industrial establishment shall be punishable with a fine which may extend to 100 rupees, and in case of a continuing offence with a further fine which can extend to the 25 rupees for every day after the first during which the offence continues. Because the problem is for the labor law, because why we feel so the poor implementation of the labor law is because the fine and the liabilities are very less. So, employer know how to escape from this kind of the responsibilities. No prosecution for an offence punishable under this section shall be instituted except with the previous sanction of the appropriate government. Yes, if someone wants to prosecute the employer, so they have to take the permission from the appropriate government. Directly the person cannot be prosecuted, employer cannot be prosecuted. No court inferior to that of the metropolitan or judicial magistrate of the second class shall try the offence. So, they are the competent authority to take up this thing. Section 13A, it talks about interpretation of the standing order. It means if any question arises as to the application or interpretation of the standing orders certified under this act, an employer or a workman or a trade union or other representatives body of the workmen may refer the question to any one of the labour courts constituted under the Industrial Dispute Act 1947 and specified for the disposal of such a proceedings by the appropriate government by notification in the official gazette, and the labour court to which the question is so referred shall, after giving the parties an opportunity of being heard, decide the question, and such decision shall be final and binding on the parties. Because we are talking about if there is any ambiguity, if there is a problem in understanding, there is a problem arise, there is a issue is relating with the question relating to the application or the interpretation, if they are having so many meaning to it, then this kind of the matter can be decided, interpretation can be given by the labour court, and the decision of the labour court would be final. And for this, before deciding anything, labour court would be giving the opportunity to both the parties, and accordingly the decision would be binding on the parties. Section 13B, it talks about acts not to apply to certain industrial establishment, because we are having the other rules where this act will not be applicable. So, it is very clear that this act will not be applied to the industrial establishment insofar as the workmen employed therein are the persons to whom the fundamental and the supplementary rules are applicable. Civil services classification, control and appeal rules are there, civil services temporary service rules are there, revised leave rules are there, civil service regulations, civilians in defence services, and rules or the Indian Railway Establishments Code or any other kind of the rules or the regulation then may be notified in this behalf by the appropriate government in the official gazette. That will, these kind of the rules will not be applicable. They are governed by the different acts. Power to exempt, because the appropriate government may by notification, this is where we would be saying here the absolute liberty can be given. Power to exempt, the appropriate government may by notification in an official gazette exempt conditionally or unconditionally any industrial establishment or class of industrial establishment from all or any of the provision of this act. So, it means we are saying that is this is the, because appropriate government is with a wide power, they can exempt any of the establishment from this, not to have this standing order on a condition, because absolutely they can give the exemption to any of the industry, or conditionally they give the exemption to any of the industry. So this is with the that is the appropriate government. Section 14A, it talks about delegation of powers. The appropriate government may by notification in the official gazette direct that the any power exercisable by it under this act or any rules made there under shall in relation to such a matters and subject to such a condition, if any, may be specialized in this direction, be exercisable also, where an appropriate government is a central government, by such officer or the authority subordinate to the central government, or by the state government, or by such an officer or the authority subordinate to the state government as may be specified into the notification. It means we are talking about this kind of the power can be delegated. If it is a question of the central government, then the central government can give this kind of the authority to whom? That is to any of the subordinate, they can delegate this power. If it is a case of the state government, again the state government, they can delegate this kind of the authority to any of the subordinate, where the appropriate government is a state government, by such officer or the authority subordinate to the state government as may be specified into the notification. They would be notify this thing into their official gazettes, because that is their duty. They have to notify. If they are delegating the power, they must have to mention it. Power, section 15 is talking about power to make rules. So appropriate government may, after previous publications by notification in the official gazette, make rules to carry out the purpose of this act. In particular and without prejudice to the generality of foregoing power, such rules may prescribe additional matters to be included into the schedule and the procedure to be followed in modifying standing orders certified under this act in accordance with such an addition. So sometimes the appropriate government thinks so, like this kind of the rules, more rules has to be added, or additional matter has to be included into the schedule, or the procedure can be, this kind of the procedure has to be followed in modifying the standing orders certified under this act. So like they can add it, and they can set out model standing orders for the purpose of this act. Like they can refer this model, then prescribe the procedure for certifying officers and the appellate authority. The appropriate government, what they can do is they can prescribe the procedure of the certificate. What is the procedure? How this kind of the thing can be, standing order would be certified, and who would be the certifying officer? They want to make the changes, they can go for this. Or the appellate authority prescribe the fee which may be charged for the copies of the standing order and entered into the register of the standing order, because if someone wants to see what has been given into the standing order is, so like they can make the provisions. After giving the fee, they can take a copy of the standing order and provide for any other matter which is to be and may be prescribed, provided that before any rules are made under clause A, representative of both the employers and the workmen shall be consulted by the appropriate government. Because in India we are having the tripartite system, because normally the government is taking into the consideration of consulting the trade unions, that is a workman side, or to the employer before making these kind of the changes. Every rule made by the central government under this section shall be laid as soon as may be after it is made before each house of the parliament while it is in session, or for a total period of 30 days, which may be comprised in one session or in two or more the successive session. So because if any of the government is coming up with these kind of the proposals, that is, it is obvious they have to follow the rule which has been given it for the parliamentary proceedings. The matter would be coming before the standing committee and from one house to the other house. So because, and they can go for this kind of the practice in their particular sessions. So they can they have to consult both the parties. If both the houses, if they are okay with that, they can come up with the new things. If before the expiry of the session, immediately following the session or the successive session aforesaid, both the houses agree in making any modification into the rule, or both the houses agree that the rule should not to be made, or the rule shall thereafter have effect only in such a modified form, and or be of no effect as the case may be. Because why this is very important is because if we are talking about the labor reforms, the things has been done in such a way only, because this kind of the draft has been that has been gone through that process only, and that's why they the public opinion and both the houses are very important when we are deciding something. And however, that any such modifications or annulment shall be without prejudice to the validity of anything previously done under that rule. So, we have discussed the standing order in detail, and because the standing order is very important, but when we talk about the standing order, applicability of the standing order is the threshold under the standing orders, and 1946 has been fixed 100 only, or if the government feels so that is a number is lesser than 100. But if we are talking about the course, now this threshold has been increased, and so because this number is has been increased from 100 to 300. So the basic idea is, and into the standing into the court, now the punishment has been increased. So just to we have made the more modification into the standing order and in other codes, in other acts, for the better implementation of labor law. So thank you so much. This is only this much is from my side. Thank you.
Many a times we all think, who am I? Why am I doing whatever I am doing? Why do I feel attracted towards others? Why do I feel very aggressive in certain instances? Why certain people or certain type of acts they repel me? Why is it that I always search for certain things which look very ambiguous? These are the things, these are the questions that all of us experience, all human beings. And you would realize that many a times certain domains of knowledge, especially within social sciences and all sciences at large, when you look at it from a philosophical point of view, they would try to give you the answers to these questions. Now, one of the branches of understanding which helps you understand things much better, which also helps you understand not only what is visibly present before you, what is glaringly apparent to you, rather which also tells you what is not visible at all, what goes within. Okay. And this is the subject knowledge, what is called as psychology. It is not only that it helps you understand the manifested behavior, the overt behavior, how you talk, how you speak, how you say it, how you interact, how you respond, not only that, but also what goes within, what makes you do this, what makes you think this way, what makes you act that way. Why is it that certain things you appreciate, certain things you feel attracted towards, and why is it that many a times in certain type of situations you feel you should completely go out of it, you should not get anyway involved into it, the repulsion. Why is it that certain acts, although you do not appreciate, still you get involved into it? Then you reinterpret your own behavior and you start giving birth to certain type of experiences, shame, guilt, pleasure, appreciation. You see world in a particular way, you analyze it in a particular way, you derive emotion out of it, feeling out of it, and the mix of what you perceived along with what you experience, it makes you act in a particular way, respond in a particular way. Your response is received by somebody else, and then the other person also responds in that situation. Now, there are situations where several people interact simultaneously. The situation remains constant and different people interact at the same time. You realize that your identity gets lost. You are not an individual. You act what is called as group behavior. You realize that you do not have an explanation for either favoring somebody or completely being unfavorable to the other person. You later on realize that it was a favorable or an unfavorable attitude towards that individual. You realize that you repeat certain form of behavior. Why? You do not know. People tell you that such type of repetitions are not normal. Human beings largely do not do that. And then you realize that okay, this is a particular pattern of a behavior for which I require the help of a specialist. The specialist tells me that this pattern of behavior is given a particular taxonomy, a particular nomenclature, which is either some aberration in the normal behavior, it is a neurotic form of a behavior, psychotic form of a behavior, it could be a psychosomatic response. And psychology, it covers all of this. So, if you want to understand yourself, if you want to understand others, this is the subject which helps you achieve that target. It is behavioral sciences that makes you understand human beings, human responses, human existence in complete totality.